Hi, this is Todd Mitchell with MBH. I got Colleen Sweeney here with me. Just some housekeeping things before Colleen jumps into this webinar on the NVAR contract updates. If you have questions, we will not be taking questions at this time. It bogs down the information that's coming down and slows us down. Please put your questions in the chat, and Colleen will be sure to follow up with you. If you have, feel free to email her directly. You can see her email on the screen at this time and her contact phone numbers as well. So, best place for questions is in the chat. I do see one question already on the presentation. The slides will not be presented, but we do have content to be provided as in the future. So that will be coming as well. So take notes and we can follow up. At this point, I will pass it over to Colleen.
All right, thanks, Todd. I appreciate it. Well, thank you guys again, everyone, from joining us. I want to make sure that I go through all of the form changes and get your questions answered, and everybody is ready for July 1st when these forms actually go into effect. So do feel free to reach out to me if you have any questions about the presentation, and also if you have any contracts to send our way. We're always here to help you at MBH and Champion and District. All right, so I also want to tell you how important education is to us, and make sure that you guys know that once a month we have free CEs for you to attend. The QR code is there if anybody wants to take the classes. Our next one is July 8th, Property Conditional Disclosures. Feel free to log on to any of those classes. We really want to make sure that everybody is investing in themselves. And I'm a huge believer in education, which is one of the reasons that I really love bringing these form change classes to you guys. So getting started here, I want to just start with why did the forms change? And if you've done my webinars before on the form changes, this is a consistent slide for me, but I particularly like it for July 1st. And let me just start with each year the law changes on July 1st, usually in Virginia. And the forms have to be updated to comply with legal requirements. But changes are also made every 6 months or as needed. As you guys may remember with the NAR settlement, some additional changes were made more than twice that year. But what really drives the changes is the legal hotline reports. Agents and brokers call in and make reports, and then there's a standard forms committee. And I see some people are on here from the standard forms committee, so they should all be thanked for their hard work. But also for you guys to know that you can apply to be on the Standard Forms Committee. You know, if you have a passion for the forms, that's something that you can do through NVAR. So again, because the laws change frequently and the forms need to be legally compliant, that's a constant thing that happens, but you'll see a lot of the changes today are because of the Virginia legislature changes. So again, you all can, as NVAR members, you can influence the changes by calling the hotline. You know, what happens is when we see the same issues arise over and over, we know that the forms need to be changed for that reason. So wanted to make sure that you guys know that these are your forms and you have a say in them. All right, so what we're here for, the NVAR form changes that are for July 1st, 2026. And as I like to start, I want to tell you where you can review the form changes. The educational version of the form changes are already available on the website. You see that QR code, and that's the page that it's going to take you to. It's my understanding that NVAR mailed these out to all of its members as well, so you can access them that way. But just for your convenience, I do have that QR code for you as well. All right, so the roadmap, really the best thing to do is just look at what we're going to talk about today, which is all of the forms that have changed. So K1209, the sales contract for unimproved land, has changed. The K1308, the buyer's acknowledgement of potential adverse consequences. K1321, residential sales contract. K1344, contingency clauses and addendum, and K1354, the lease. K1360, the private well and or septic inspection contingency addendum. K1387, landlord notice regarding non-payment of rent for a lease. K1406, the sale of property subject to lease addendum. All of the financing contingencies, so K1359, K1339, 1340, and 1372. And so that's just an overview of what the changes are. And then I'm going to obviously walk you through each of them carefully. So we're going to start with K1209, which is a sales contract for unimproved land. One of the things I always like to tell you, what's the impact of the change? Well, I do not anticipate all of these changes unless you're working with the lease a lot. These are really going to have a substantial impact on how you run your business. These are changes that are just improving the forms, but each change is important. So you really set yourself apart as agents when you understand the sales contract. I get it. There's so many lawyers in this area that when you have them as potential clients, you want to make sure that you understand the provisions and how to talk through them. So the first change we see is on the 1209 is the updated paragraph for the definitions to match the residential sales contract. So specifically, we see the changes ratification, definition, days, time of day, seller subsidy, delivery, business days, and notice voiding contract. All of those are things that are going to be changed. But this is not a big change because this is consistent with what's in the residential sales contract. So all of these changes are going to be familiar. Paragraph number 31 also was changed to match the additions to the residential sales contract. All right. Specifically, remove the extension of review period for common interest community resale certificate. So this is an overview. So what does it look like in terms of the changes? So here's the red line version, but I don't want it to be overwhelming to you because what you need to know, it's consistent with the residential sales contract. So for those of you that like the red line approach and understanding, what was added, that information's there for you. So let me show you what it's going to look like. So as I always do, I showed you the old paragraph. So the K1209 sales contract for unimproved land for paragraph 25, actually, the definitions is in there. The new paragraph now is going to look like this, okay? That's the, oops, sorry about that. Oopsie. That's what the ratification or ratified, that now matches the standard, the residential sales contract. Remember paragraph B for delivery, that was updated. Days or days, again, these are all consistent with the residential sales contract. Business days, a reminder that all reference to time is for Eastern time zones. The notice voiding the contract, this is the biggest change. But again, this is consistent with already in the residential sales contract. Do keep in mind, notice voiding contract means that NVAR form K1367 entitled notice voiding contract. And remember that the notice removing the financing contingency refers to form K1331, okay? And then seller subsidy is now defined just as it was in the past for the updates in reference to in the residential sales contract. All right, so the next change we see in K1209 sales contract for unimproved land is old paragraph 31. And what has been removed is highlighted there in red. So extension review period for the common interest resale certificate has been removed. And now it's going to be consistent with that removing, and again, consistent with the residential sales contract. Remember, the extension of review period for the common interest community resale certificate was removed because it's now negotiable pursuant to the Virginia Resale Disclosure Act. So that no longer needed to be in there, and that update had already been made in the residential sales contract. So those changes are just to bring the sales contract for unimproved land to be consistent with the residential sales contract. So none of those are going to have a huge impact, but it is important for consistency's sake. So now the one that everyone always wants to listen to is the residential sales contract. And what I want you guys to know here is this change, these changes are important, but they're not, again, going to substantially alter how you conduct your business. All right. 2 paragraphs contain updates in the residential sales contract. The first one is paragraph 1, which is probably the biggest change. And I'm going to walk you through this one carefully because it's a clarification of parking and storage unit information. And then also what we see is a change to paragraph 19, which is in title. And this language was updated to reflect that all parties to the contract will sign and deliver the required documents. I'm going to give you the why to that when we get to that, and I think it's going to help everybody understand. All right. So, parking spaces. This is an important refresher, and NVAR has been teaching these form changes, and I understand that a lot of people just didn't understand the basics of parking spaces. So in order to really be part of this education, I wanted to talk you through this a little bit. So what we know about parking spaces is there's two different types. They can be owned in fee simple, or they can be a limited common element. These are the ones that we really see in Northern Virginia. The vast majority of them, honestly, are limited common elements. But because there's two kinds, you really need to be able to differentiate between them. So again, you are gonna have to decide, are they owned in fee simple, or are they limited common elements? That's an important aspect of understanding parking spaces. So how do you look to see how a parking space is owned in a condominium? Well, the answer is a condominium declaration, okay? So every condominium is governed by a condominium declaration. It's recorded in the land records. The document sets forth the rights and the obligations of the unit owners in the condominiums. And it also talks about the ownership of parking spaces in the condominium. And so this is an important aspect for everyone to understand. And one of the reasons this was updated in the residential sales contract is people don't necessarily understand parking spaces, and information wasn't being put correctly in the parking spaces aspect of the contract. So where do you look? So the limited common elements parking spaces are designated again in that condominium declaration, and they're for the use of a unit to the exclusion of other units. You must review the condominium declarations for the exact specifics because they're not the same for all of them. The limited common element parking spaces are attached. That's the concept. They're attached to the unit, okay? They don't exist separate from the ownership of that unit, and they pass with the title to that unit. Some limited common elements are subject to the control and authority of the board and can be reassigned, and that's usually true with parking spaces. Okay, this is an important thing to keep in mind when you're looking at limited common element parking spaces. So the far less likely scenario when you see parking spaces in Northern Virginia are that these are fee simple parking spaces. It's a separate entity from the unit. It's assessed separately by the city or state for taxes, so it's going to have a separate tax ID number. The parking space is going to have its own legal description and therefore a separate property tax ID and bill. It's deeded and transferred separately from the condominium unit as a fee simple interest. This is really important to know because when you're writing a contract, if you intend to convey the parking space, or you intend that your buyer is going to get the parking space, you need to make sure if it is a fee simple parking space that is being addressed correctly. So my practice pointers, even if it is owned in fee simple, understand the condominium declaration still must be reviewed because the condominium declaration can restrict the owner's rights related to transferring a parking place. Parking spaces are also relevant to a lender's interest, so selling a parking place can be complicated in terms of the loan, and if the loan is relevant to the parking space, the lender may have to get involved if somebody from the unit is deciding that they're going to change the way they're doing the parking space. All right, so the key takeaways for you all as agents is set expectations with your client. For example, if they are choosing a unit because of the parking space by the elevator, let them know it can be reassigned. Okay, and that's really important, and most people don't understand that. So why might parking spaces be reassigned? Well, they're fair housing accommodations. So if somebody believes that they have a parking space that is theirs right next to the elevator, and somebody comes in and they're in a wheelchair and they ask for an accommodation, they're probably going to get it. And you don't want your client to come back to you and say, you promised me this parking space, because that is not how condominium declarations and parking spaces work. Deeds also may not include parking spaces. I tell you this because it happens not infrequently, where an agent will call me and say, listen, you really made a mistake. There's not a parking space, and there was a parking space that was conveyed. Well, what we are going to write in your deed most of the time is the limited common elements are conveyed. And the limited common elements, if it is the way the parking space is outlined, is going to be in the deed just as a limited common element. You do want your contracts to be accurate always. So if a contract notes the wrong parking spaces assigned, it should still be corrected. However, the most important thing is a clear expectation of the number and spaces and not the location of the parking spaces. And again, because they can be reassigned. If the parking space, again, is not in the deed, don't panic. I want you guys to be able to convey. You can always call us an MBH and we'll talk you through it, but we want to make sure that your clients are comfortable, so don't panic. One other thing, just as a title company, we always like to remind people, limited common elements like a parking space are not covered by title insurance. Okay, so my guess is you're saying, Colleen, why did we just go through that? That seemed like quite a side quest we went on. Well, now we're going to look at the change to the residential sales contract. So the old paragraph, just from earlier this year, January 1st forms release, was the real property, and what you can see is the parking space is highlighted there. Now we see something a little bit more extensive, because it has parking and storage. And so for parking, you're going to say, is it a limited common element? Is it assigned parking? Then give that ID number, unassigned number of spaces, or is it a fee simple parking space? And if so, we need the tax ID, because that needs to be addressed as part of what is being conveyed also. And because the storage units are often limited common elements as well, there's now a place to put that. So the background I just gave you was so that you could fill this out confidently and understand what needs to go in there. Now, I have been talking to NVAR as they've been teaching this, and so I really wanted to get their frequently asked questions. I try to anticipate the questions y'all might have. And so just to help you, what if I'm not sure if it's an assigned or unassigned parking? Well, really, the listing agent, the seller should be able to provide that information initially, but you're going to also want to follow up. All right. What if there's more than one assigned parking ID number? Then you can put them both in there, and you should. As I said, we want to make sure your contracts are accurate. Okay. You can put both assigned parking IDs in the space. And so what if there are two parking spaces with the same ID number? Well, and that happens often more with townhouse units, but put the parking space number twice. So if it is an example of it's unit 2B and there's two parking spaces identified as 2B, you can write 2B, comma, 2B. And that is one of the ways that you can be sure that it is accurate and clear about what is being conveyed. So this one I think is going to be the biggest one in terms of the contract changes that people are going to take a little bit of time. But again, good for you for being here, getting educated ahead of time. And if you have questions, I'm certainly here to help you as well. So the next part of the change for the residential sales contract is, as we talked about, is the title paragraph. And this is the language was updated to reflect that all parties to the contract will sign and deliver the required documents. And so why the change? I always think this is important. So as many of you probably know, the Department of Treasury put regulations into effect on March 1st, 2026 related to FinCEN requirements. And this had to do with if there was cash transactions in legal entities. There were lots of challenges prior to March 1st when it was supposed to go into an effect. But after it went into effect on March 19th, the Eastern District of Texas issued a court order saying that the regulations exceeded the department's authority and basically said that the FinCEN requirements were being suspended until further notice. This is really important because in the title industry, particularly the attorneys on the attorney roundtable and the attorneys on the standard forms committee, in reviewing the contract, realize that this ruling could be vacated at any time, and the residential sales contract had to ensure that the mandatory reporting requirements had to be complied with by both the buyer and the seller. So when FinCEN, if FinCEN comes back online, there are absolute mandatory requirements with very large potential fines in the event that things aren't reported exactly as required. And the residential sales contract did not have all of the required information, a way to make sure that all the required information had to be provided. Now, I'm going to tell you, this is a balancing act because we don't want anyone to be asking for too much information. So the required documents are only those that are necessary to complete settlement and to ensure that a title policy can be delivered. Anyone that knows attorneys, and me in particular, hate the word reasonable, right? So what we were trying to do was find the right language as the committee for NVAR to come up with some information about where is the right amount of information that should be provided. So here's the red line version of the changes. It's really purple, but red line is how it's usually referred to. But you can see there specifically that now it's going to say parties, as opposed to just the seller, will provide such information, sign and deliver such affidavits, lien waivers, tax certification, and other documents as may be required by the lender, title insurance company, settlement agent, or government and authority, all as necessary to complete settlement and ensure title. So again, the goal here was to make sure that title companies can get the prerequisite required information, and it was part of the contract. So that is the second change to the residential sales contract. I don't think it's going to have a big impact, but it was an important change that needed to be addressed. All right, so the next form that changed was K1308, the buyer's acknowledgement of potential adverse consequences. And so what changed here was the form was modified to cover two potential risks that an agent would want their client to acknowledge could have potential adverse consequences. And the sale of homes subject to a lease addendum and the escalation addendum. If this form is not in your regular rotation, you should add it and use it to protect your license. This is a really good form that I know NVAR wants to make sure that is out there for you guys. The document, again, doesn't get submitted with your offer. It's for internal use only and should be with your agency documents. But in the event that something happens and somebody is unhappy after the fact and you've had this form signed and it shows that you discussed this with them, it's going to be so important for you. So going to the specifics of the change, I just want to say part one, no changes were in part one of this form, but it's so important to be familiar with it. And one of the things I just wanted to point out is there is an other section in there at the bottom. If your factual situation doesn't fit into anything above there, but you're concerned that the buyer is making a decision regarding something and it has potential adverse consequences and you've let them know about it, you want to use that other section, okay? Where we see the actual change to the form was in part two, and despite the risk of potential adverse consequences, okay, a buyer elects to submit an offer and ultimately ratify the purchase agreement with the following. And again, what was added was that sale of home subject to lease addendum and the escalation addendum, okay? In terms of practice pointers here, know that you should check all that apply. You don't have to only use it for one thing. Lots of times we see a post-settlement occupancy and potentially an escalation addendum together, so make sure that you understand you can do that. And keep in mind, if your facts result in a buyer taking a risk not listed, that other box should always be utilized. Right, so that's important document for you guys to cover yourselves with. All right, K1344, the contingency and clauses and addenda. There's one change to this form and it appears as follows, okay? Paragraph 1 in contingencies the sale of buyer's property and kick out subparagraph 2. All right. What was changed was buyer's property will be listed exclusively and actively marketed by a licensed real estate broker and entered into multiple listing service in active status. That's the language that was added within and then blank days after date of ratification at a price not to exceed, and that is left blank also. This is not a big change, but obviously consistent with some things that has happened with MLS. So what does it look like? What is the change? So the old paragraph 1A2 from July 24 looked like that. And now the new paragraph is going to be in active status. So that's important change, but one that probably isn't going to have a big impact. So the lease, let me just say that the lease changes, a lot of them are driven by law changes, and we even know that some are going to go into effect next July. But I want to really just say the subcommittee works, the subcommittee members that work primarily in this area that see documents, see how document is working, the lease is working, or how it needs improvement. That's something that they do a lot of work on. Leasing is something that is its own separate entity. So I want to just say that there's a lot of people that put effort into this because title companies, we do not obviously work with leases. But the law drives these changes as well. And that's why you see a lot of changes to the lease July 1st. All right, I'm going to go through a summary of the changes. The first one is that the opening paragraph moved the identification of the property up to the opening paragraph. That was something a lot of people had been asking for quite some time. Paragraph 1 added the words beginning on for monthly rent. Added the VRLTA definition of authorized occupants to the lease and removed the list of occupants. And paragraph 12 added well and septic to list of systems. Other changes you're going to see in the lease in terms of the summary. Paragraph 14 was amended, the language to remove tenant's obligation to maintain exterior gutters. Paragraph 24 was amended to include all of the elements of early termination of occupancy, uninhabitable dwelling unit, transfer pursuant to the Service Member Civil Relief Act, transfer of all other tenants, transfer of the landlord, amended transfers pursuant to the Service Member Civil Relief Act. Sorry about that, I can't talk. Paragraph 27B, failure to pay rent to reflect 14 days from 5 days for cure period. This is to reflect, again, a law change from the General Assembly. And the ending paragraph deleted extraneous information about listing brokerage and tenants brokerage for informational purposes only, just to make the form a little more streamlined. So here's what this is going to look like, okay? So again, the lease, this is now going to, you see that the property, the identification of the property is moved up, and parking space information was also added. You can see that's in the red down there, okay? The beginning on is in paragraph 1 was added, which is in purple there. And the definition of authorized occupants to lease was added right to as it is in the VRLTA, and removed 2 lines in the list of occupants' names. And that's because the names of authorized occupants, these are people who are entitled to occupy the dwelling unit with the consent of the landlord, but they didn't sign the rental agreement and therefore they don't have financial obligations. This is consistent with the definition, but it was being used incorrectly. And so adding the definition allowed to take off some lines there. All right, so paragraph 12 added well and septic to the list of systems. Paragraph 14 was amended language to remove tenant's obligation to maintain those exterior gutters and drains, or just exterior gutters. Again, the amended paragraph 24, just in the way that I had talked about, and amended the transfer pursuant to the Service Members Civil Relief Act to reflect, again, the General Assembly's updates. I wanted to just give you the red line version of how the transfer pursuant to the Service Members Civil Relief Act was outlined. And so it is House Bill 174, which required this. And you'll also see it reenacts 55.1, 1235 of the Code of Virginia. So in terms of practice pointers, the updates include removing the requirement that the lease cannot be terminated more than 60 days from date necessary to comply with orders, and changes the timing requirement of delivery of proof of order letter to a time prior to termination date. This again is something that we've seen a lot of changes in terms of Virginia trying to align with the federal act as well. All right, the failure, oops, I'm sorry, I think I went past it. Amended paragraph 27B, wow, sorry about that, guys. It doesn't want to do this. Amended paragraph 27B for failure to pay rent to reflect 14 days from 5 days. Again, that is just consistent with the law changes. And deleted these extra all this extra information that didn't need to be in there. And the goal is always to have a more streamlined document. All right. So those are the lease changes. Again, we always anticipate we're going to see a lot of them in July, and this was certainly the case. So the next one is K1360, private well under septic inspection contingency addendum. So here I'm going to talk you through the changes. Paragraph 2B1 was amended to address seller's responsibility of removing impediments preventing access to the septic inspector. All right, this change gives an automatic extension of the contingency if impediments are not removed prior to the inspection. And it added language from the new law defining readily accessible as no more than 30 inches from the surface. And if seller cannot or will not remove the impediments, the buyer can now void. This had been missing, and it was an important aspect of that hadn't been available. It kind of left people in a deadlock. So what does readily accessible mean? Well, according to the Virginia Code, as of July 1st, it means approachable, openable, or enterable for inspection without the risk of damage to any property or alteration of the accessible space, equipment, system, components, or opening. It does not include removal of surface material exceeding 30 inches in depth to uncover the septic tank access lids, distribution devices, or other inspection ports. So what I'm going to do, I'm just going to give you a second. There's a QR code for anybody that wants to kind of see how the legislature has addressed this and kind of how this came about. But I can just tell you that it came up a couple times for in my office. As an example, somebody put a patio over what needed to be accessed for the septic system. And obviously, it was going to take a lot of money to get that addressed. And the parties kind of got at a standstill about what to do about that. And so several issues came up like this, and making sure it was more clear how septic inspections were going to happen and everybody's responsibility and rights. So I'm going to talk you through this. Practice pointers. So starting point is prior to the inspection, the seller is obligated to remove any landscaping, personal property, or any impediments. That's a starting point, okay? Again, readily accessible is now defined by the code to give everybody good feedback on that. If the inspector determines the system is not readily accessible, the buyer must deliver notice within 1 day. That's not a long time. So within 1 day to the seller to remove the impediments. Seller has 5 days to deliver the notice that the impediments have been removed or they're not going to remove them, okay? And then the buyer has a unilateral right, just at their sole option. They can void by delivering the notice voiding the contract, okay? And the inspection period, this is important to note, that the inspection period starts the day the seller delivers notice that the impediments have been removed, okay? And so there's a little bit of back and forth here that I wanted to make sure everybody was familiar with, and try to understand the process, because 1 day on anything is not very long. So keep all of this in mind, and feel free to reach out. I know that there's going to be a little bit of confusion, but the goal here based on law changes was to try to make sure that everything was clarified and what happens when something isn't removed, that the buyer has a choice. They've negotiated for this and they should continue to have what they negotiated for. All right. So this is what the old paragraph looked like from July of 25, and here's now what the new paragraph looks like. Oops, sorry about that. And so I showed you the red line version, but I wanted you to also see what it's going to look like in the actual educational version of the forums. And I would strongly, you know, I know NVAR did send them out to everybody who is members. They are on the website, to go ahead and take a little bit of extra time to read through this before you are on July 1st trying to get a septic inspection contingency in place. Okay, so K1387, landlord notice regarding non-payment of rent related to the lease. Well, we've already talked about what changed, but it was formerly entitled the 5-day notice. So we now know that it's not going to be entitled that because it changed the 5-day notice to 14-day notice. And again, why did this change? This is a law change, and it goes into effect on July 1st. For those of you that do leasing, you may want to just check out why the legislature made these changes. And here's the link, the QR code that will take you to it to kind of follow how the bill went through the Virginia legislature. Again, it's not going to come online. You might not be able to read it until July 1st in terms of the way it is in the code, but that's a good legislative history that I made sure that I read through. And if anyone's interested, you can use that QR code. All right. And so this one's pretty straightforward, but just to follow my steps, I always do. This is what the old one looked like, the new one. And again, that red line is pretty straightforward. It just changed it to 14 days notice as required by law. All right, the sale of property subject to lease addendum K1406. So what changed? Paragraph 2 changed, and the language was edited to address the status of the lease documents. Including a checkbox that addresses when the lease documents are unavailable, do not exist. Addressed protective language for you all as the agents that the buyer should seek legal counsel in instances where lease documents are unavailable. Okay. And paragraph 3, I added a review period for the buyer to review documents provided after ratification. Why the change? Well, the change was introduced, as you guys remember, the form was just introduced on January 1st, 2026, so it's fairly new. But modifications were made to address how it was used in the market. I think a lot of people were surprised at how often there is a lease on a property that is being sold, but the buyer isn't reviewing the lease. And that I know for me, that was shocking that would happen, but it does apparently quite often. And so this information was added at the suggestion of the board, I believe the NVAR board. So here's the red line version of what the document looks like now. And again, it's going to say the lease and any addenda have been delivered to the buyer, have not been delivered to the buyer, or are unavailable or do not exist. And also this next paragraph says how long, and it's negotiable, the date before the full copy of the lease will be provided. It does default to 2 days if it's not filled in. If lease documents are unavailable or do not exist, buyer is advised to consult legal counsel for understanding of obligations under oral or unwritten lease and provisions of this addendum that may not apply. If the lease documents have been delivered to buyer prior to ratification, this review period does not apply. This is really, really important for you all to understand and spend a little extra time on this. And again, buyer in the buyer's sole discretion can deliver to seller notice voiding the contract after the delivery of the documents if it's not consistent with what they wanted. Again, if the seller fails to comply with the requirements of the delivery, buyer has an option to void as well. But if they don't, the seller can, if they haven't done it and the seller can get the documents to them, they have the right to do so. So this is really important. I'm always very nervous when people talk about a buyer purchasing a property and not knowing anything about the lease. But this was an acknowledgement that apparently sometimes that does happen. So I always would just remind you to be careful. Again, this is a great document because the buyer is advised to consult legal counsel. And I highly would suggest that you all encourage your clients to do so if there's no lease on the property and they're buying subject to somebody living in the property. All right, so how does this look? Well, again, this was new as of January 26, and for paragraphs 2 and 3, and this is now what paragraphs 2 and 3 are going to look like. You'll see those check boxes are different, that language is different, and paragraph 3 is still in 1406 in its original form. It's just now paragraph 4. All right, so the conventional financing and appraisal contingency addendum is K1359. All of the financing contingencies changed in the same way. So I'm going to start with 1359 because it's the one that's used most often. And so for the last several years, there's been confusion related to the market interest rate sentence in the financing contingencies. Lawyers, agents, brokers, judges have not read this the same way. And so specifically, the following language has been the subject of confusion, and it is the interest rate for the loan is at an initial interest rate not to exceed blank per year, percent per year. And so if the buyer applies for an interest rate above what is stated, they will be in an alternative financing situation. I know how many times I have taught that and people said, nope, you're wrong, Colleen, that is not true. And I'm going to walk you through why it is true. And I'm going to tell you why it matters. And that is because there was litigation on this issue. And a buyer got a lender rejection letter. Seller was not pleased. And I'm not involved in the litigation, but basically what I understand happened is the agent was like, oh, you're covered. You got a lender rejection letter. Seller said, well, it's not quite that easy. And they filed a lawsuit and they did discovery and they asked the lender, what was the interest rate that they applied for? Well, unfortunately for them, it was a rate that did exceed what had been written into paragraph 1 here. And at that point, they were in alternative financing and they were in default of the contract. So how do we get there? People are surprised by this. So I'm going to tell you that NVAR has been trying to teach why this is important. So these are the formal educational pointers that I have included, and I want to just show you some of the information. So the interest rate, again, paragraph is there. You always want to fill in the interest rate. Do not state market rate, okay? Remember, the buyer is required to get a lender rejection letter to utilize this contingency. And if your client applies for a loan at a higher rate than stated, it puts them in alternative financing. Why? Because paragraph 2 says that specifically. The financing contingency will not apply to any alternative financing, and alternative financing is a change in, and ultimately, if you read it, it says interest rate, okay? So I know NVAR was trying to clarify this for a long time. And ultimately what was determined is the best way to provide clarification was a definition. So interest rate is defined in the financing contingencies as follows. It's a paragraph that is going to be in all of them. I'm going to walk you through it in terms of where it is and what it says specifically. So breaking down the language, what it says is interest rate means the maximum interest rate that the buyer will accept without points. That was clarification. It must be a specified percentage rate and not market rate. Buyer will instruct their agent after discussing with their lender of choice what interest rate to enter into the financing contingency addendum. I feel like this is good for you all. It gives you a lot of protection. It's not your job. It is your client's job, along with their lender, to determine what interest rate should be put in the financing contingency. Market does not work. Okay. If a buyer, again, now this is all in this definition, if a buyer fails to specify a percentage rate or designates market rate, then specified financing will revert to alternative financing. All right, this is the definition. So keep going on this. If a buyer fails to make a written application pursuant to the terms set forth in paragraph 2 of the contract, or if the buyer elects not to lock in the interest rate, and the buyer's loan is rejected at a rate higher than the interest rate specified, then the buyer will be in default. But here's the thing. They're not in default unless they fail to complete settlement by settlement date. So obviously, if they bring cash to the table, then they can still do that. But this, again, is trying to provide protection for you all, education, so everybody understands what is covered. There's always going to be gray in any contract, but this is something that had so many different people's felt that it meant different things, that the goal was to provide some clarity. So what does this look like? So K 1359 paragraph 1 was revised in January 2026. That's what it used to look like. And now you'll see it under paragraph 1B is this interest rate, that what I just broke down for you sentence by sentence is exactly what is written there. Again, it's written to all of the contingency forms, financing contingencies. So it's important for you guys to know where it is. Okay, so for the VA financing contingency, just so you know, again, this was updated January 26, 1339, is now going to have this language in it. And that's where the interest rate paragraph is going to appear. So that's for the VA financing. For the FHA financing contingency addendum, here's the old language from just January, and here's the new language and where that interest rate is going to appear. It looks very similar, just so you know. The USDA financing contingency, again, the old paragraph and now the new paragraph. I went back and forth about whether to show you this in all the different formats because I don't want it to be more complicated than it is. It's the interest rate paragraph changed in all of them. It was inserted in all of them, but it is the same. But it's important to know that it does apply to across all the financing contingencies. All right, so K 1401 solar panel addendum to the sales contract. What changed? An administrative change was made to this document. Everywhere it previously said notice to void a contract, and now says notice voiding contract. And that is, again, to be consistent with the residential sales contract that added the definition in paragraph 27 related to notice voiding contract means, again, that NVAR form K 1367 entitled notice voiding contract. So that's all of the changes. And let me just show you where that is in the now one thing I do want to tell you guys, I only showing you this in the one paragraph 2. It appears a couple times in the solar panel contingency addendum, but just so you know, it's still the same thing. It's now saying notice voiding contract. It was considered an administrative change, but something I wanted everyone to be aware of. So again, I always like to point out one other thing, because we do see a lot of mistakes with escalation clauses. NVAR does have that escalation addendum. Always know that it's available to you and download it again each and every time. But it's one other thing that I just want to point out, as it's an important aspect of the work you're doing, and we certainly have seen lots of escalation clauses recently. Again, I'm so glad that you guys joined me. I don't think any of these changes are going to be really difficult for you, but education is so important, and we want to be your partner for education. So feel free to reach out. Again, there's my contact information. And we're here to help you again with your contracts, with your education, and certainly to answer your questions. So thank you guys so much for joining.